lecture ADR. Okay, so just would like to announce that the ADR exam will be held. Some announcements. ADR exam will be held via online. Okay, meaning that kita akan ada peperiksaan ADR secara online dan masa yang ditetapkan adalah selama tempoh 2 jam lebih kurang, and you guys need to answer 2 questions. Okay, so that is the latest information that I can relay to you guys. Yeah, and for today we are going to discuss about arbitration agreement. Okay, arbitration agreement. Dia adalah lebih kurang sama sedikit dengan apa yang kita bincangkan last week. It is just that last week oleh kerana kita guna platform Google Meet, so tidak ada rakaman lah ya. So pada minggu ni I can see that the recording has started for this meeting, and for that reason I think it is fair if let's say that I'm going to emphasize again about this particular topic. Yeah, last week we discussed about arbitration practice in Malaysia, and one of the important practice is regarding the arbitration agreement. Yeah, why arbitration agreement is very important, because again I would like to emphasize that anything and everything pertaining to the dispute, okay, is actually a contractual dispute. Okay, arbitration, when party refer the matter to arbitration, it means that they are referring their contractual dispute to the arbitral tribunal, and this is very important for you guys to note. Yeah, meaning that they are having a contractual relationship. Yeah, they have a contractual relationship prior to their reference to the arbitral tribunal. Okay, so when we are discussing about the agreement or contract, there will be 2 kind of contracts that involve in arbitration. The first contract is the main contract, and the second one is particularly towards the arbitration agreement. Okay, so when we are discussing about the arbitration agreement, there are a few elements that I think you guys need to know. Okay, first is what the agreement itself. Okay, what is the arbitration agreement itself? Secondly is what does it mean by the seat of arbitration? Okay, then we are going to look into what will be the language of arbitration. This is actually quite easy. And then we are going to look into pathological clause. Why pathological clause? Why we need to look into the pathological clause? Pathological clause meaning that we are going to look on the surface, not just on the surface of that particular arbitration agreement, but also whether that particular arbitration agreement can be enforced, whether it is operative, okay? Because this is very important. If let's say that the arbitration agreement is inoperative, meaning that it cannot be enforced. When the arbitration cannot be enforced, meaning that the party can go to the court and the court can intervene. If you still remember, we learned about the latest development towards our Arbitration Act 2005, and it involved 2 major amendments in 2011 and in 2018. Okay, the amendment is actually due to the fact that it is an intention of the legislature to minimize the intervention of court in arbitration. They are trying to minimize the intervention of the court in arbitration, because previously, if you remember, that if one party go to arbitration, the other party for sure they are going to the court. That is the trend. Okay, they are trying to challenge the validity of that particular arbitration tribunal. Under the amendment, after the amendment in 2011 and in 2018, okay, it will limit the intervention of the court. Yeah? It will limit the intervention of the court under Section 8. Okay, except in a situation where the court find that the arbitration agreement, one of it, if the court see that the arbitration agreement is inoperative, okay, and cannot be enforced, then it will actually open a room for the judicial intervention. Okay, so that's why arbitration agreement is very important, because if the arbitration agreement is inoperative, it will open the door, okay, for the intervention of the court. Okay, so this is very important. Okay, then we are going to see multi-tiered dispute clauses, multi-party and multi-contract arbitration, and related consideration. Okay, so regarding the arbitration agreement, the agreement means that it is an arbitration agreement. Okay, you need to know that it must be in writing. This is based on section 9, subsection 3. It must be based on the exchange of communication. Do you remember? Okay, if when you learn contract law, there will be an exchange of communication between parties prior to their entering into that particular contract. Okay, so any exchange of information and any exchange of communication will be considered. Okay, will be considered as a part of arbitration agreement, provided that it must be written. Okay, it must be in writing. Okay, then section 9, subsection 5, incorporated by reference. Okay, incorporated by reference. Okay, is there any question? Anybody would like to ask anything?
So far clear, Doctor.
So far clear. All right, incorporated by reference. Incorporated by reference meaning that okay, you have the main agreement. You have the main agreement. There will be a dispute resolution clause. Okay, so that's why if let's say that you are doing your internship, okay, in any of the legal firm, okay, katalah kalau you buat mana-mana internship ataupun LI dekat legal firm, okay, make sure that you get access to read into or to look into alright. Sorry, ada panggilan masuk. Alright, okay. Incorporation by reference. Incorporation by reference meaning that if let's say that you buat LI, so make sure that you have access to read into the agreement. And kalau you tengok dalam agreement, dia ada beberapa ciri dalam agreement ni. Ciri-ciri dia adalah, contohnya adalah who are the parties. Parties tu boleh jadi pihak yang offer dan pihak yang accept. Ini yang you belajar berkaitan dengan contract law satu masa dulu. You akan tengok parties, you akan tengok obligation of the parties, you akan tengok berkaitan the main object kenapa kontrak itu dibuat. Okay, is it the contract relating to the construction contract or contracts that relate to the partnership contract? Okay, so ataupun any meaning that the object kenapa kontrak itu dibuat. Then you akan lihat berkaitan dengan the correspondences of the contract, for example, macam mana cara untuk penyampaian notice berkaitan dengan kontrak tersebut. Okay, dan kemudian salah satu perkara penting dalam kontrak adalah in terms of dispute resolution clauses. Dispute resolution clauses di dalam kontrak tersebut. Okay, dispute resolution clauses dalam kontrak tersebut bila disebut sahaja berkaitan dengan dispute resolution clauses, parties if have any dispute pertaining to this particular contract. Ayat dia selalu macam gitu. Any dispute pertaining to this particular contract, okay, any particular conflict that arise in terms of the validity of this particular contract or anything that contain inside this particular contract, okay, so it must be resolved. Okay, it must be resolved through the arbitration. Okay, kalau misal kata ada clause yang sedemikian rupa, itu bermakna it is actually an incorporation by reference by the parties, so that the parties will actually will refer to that particular clause in order for them to submit their dispute to arbitration. Itu maksud incorporation by reference yang pertama. Yang kedua, when you have that particular arbitration when you have that particular clause, that clause is an agreement itself which is independent from the main contract. Okay, from the main contract. Okay. Had, ada nak tanya apa ke? Ataupun Dayana?
Tak ada lagi.
Oh, tak ada ya? Alright. Okay. So, bila kita berkaitan dengan incorporation by reference, it means under section 9 subsection 5. Okay, section 9 subsection 5 berkaitan dengan incorporation by reference. Sementara tu mungkin you guys pun boleh flick through Arbitration Act Arbitration Act iaitu kalau you boleh lihat under chapter 2 from section 9 onwards dia adalah berkaitan dengan arbitration agreement in which kalau you tengok section 9 subsection 1 it mentioned about what does it mean by arbitration agreement. Means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. Kalau dalam ni dia mengatakan bahawa a defined legal contractualship sama ada berdasarkan kepada kontrak ataupun tidak. Okay, kalau dalam ni lah tetapi lazimnya when we are discussing about arbitration agreement, although it is agreed by the parties, apa maksud contractual or not, meaning that it can be if the parties do not have any agreement ataupun if the parties have any agreement tetapi they do not have any arbitration clause dalam that particular agreement, itu maksud dia whether they do not have any contract pertaining to arbitration agreement. Okay, it does not mean parties do not have a contract. Okay, normally in arbitration matter, it always a dispute regarding to a contract. Okay, cuma in that particular contract ada atau tidak clause berkaitan dengan arbitration. In some standard form of contract, in some standard form of contract. Contoh contract kalau besok you ada rezeki, you beli rumah. In the SMP agreement, sale and purchase agreement untuk membeli rumah, cuba you tengok, you ambil convincing kan, you tengok dalam SMP, a standard SMP agreement, ada ataupun tidak berkaitan dengan arbitration. Okay, jawapannya adalah tidak ada. Sebab arbitration, sebab SMP tersebut adalah berdasarkan kepada Akta Housing Development Act. It is a standard form and dalam akta tersebut memperuntukkan berkaitan dengan sale and purchase agreement which is standardized dan dalam itu tidak menyatakan berkaitan dengan arbitration clauses. Kalau tak ada arbitration clauses, itu terjumlah kepada they do not have any arbitration, the contractual tu tidaklah maksudnya bersetuju berkaitan dengan arbitration clauses in which the arbitration will come later upon the agreement of the parties. So dia boleh jadi dua. Satu, they agreed before. Okay, apabila arbitration clauses tu incorporated by reference. Itu nombor satu. Or it can be they do not have any arbitration contractual agreement. They do not have any arbitration agreement in the first place. Okay, but they can have it later on. Itulah kita panggil sebagai ad hoc arbitration. Okay, ad hoc arbitration. If you are looking into section 9 also, okay, you all ada ke Arbitration Act di depan you sekarang? Do you have Arbitration Act in front of you now? Online okay. Kalau you ada, okay, alhamdulillah. Alright. Okay. So kalau you all tengok berdasarkan kepada Arbitration Act cuba tengok berkaitan dengan section 9 subsection 2. Section 9 subsection 2. I hope that you guys can hear me clearly Alright. Section 9 subsection 2 dia menyebut berkaitan an arbitration agreement may be in the form of arbitration clause in an agreement or in the form of a separate agreement. So inilah yang kita maksudkan sebagai the separability principle. Separability dia berdasarkan kepada perkataan separate. Okay, separability principle. Apa yang dimaksudkan dengan separability principle? Dia bermaksud adalah the arbitration agreement tu dia adalah independent clause actually. Dia adalah independent clause. It can stand on its own. It can stand on its own. Yeah. So itu yang dimaksudkan dengan separability principle. Okay. Alright. Okay. Dan berkaitan dengan separability principle ni, apa lagi maksud dia adalah, if let's say that the main agreement has been terminated, the question would be, what is the status of the arbitration clause dalam agreement tersebut? Because you have learned that the contract can be void or can be voidable. It can be terminated at the choice of the parties or termination based on the performance. Okay, kalau you ingat lagi contract can be terminated based upon the failure or default of the parties, ataupun kontrak tersebut berakhir, okay, come into an end based on the performance of the parties, or parties agreed to put an end or to terminate the agreement in the first place. Okay, so when this particular situation happen, the main question would be, what happened to that one clause of arbitration agreement in that particular contract? What is the status of that clause? Okay, so based on the separability and based on section 9 subsection 2, it clearly mentions that, in other words, the arbitration agreement can be in the form of arbitration clause in an agreement, and it can be in the form of separate agreement, which means it's going to be separate from the main agreement. Okay, it can stand on its own. Itu maksud separability. Maksudnya it doesn't matter whatever happened to the main agreement. Okay, it doesn't matter what happened to the main agreement. The arbitration clause will stand on its own. Okay, itu maksud section 9 subsection 2. Okay, you need to see this arbitration act, act 646 yang mana reprint in 2018. Okay, alright. Kemudian kita boleh tengok section 9 subsection 3, an arbitration agreement shall be in writing. Okay, it not just maksudnya bukan setakat in writing. Okay, dia di-emphasize sekali lagi in what kind of writing tu dalam subsection 4. Okay, apa maksud writing? In any form, whether or not the arbitration agreement or contract has been concluded orally, by conduct, or by any other means, or if it is contained in exchange of statement of claim and defense, in which the existence of an agreement is alleged by one party and not denied by any other parties. Okay, dan berdasarkan kepada amendment, okay, berdasarkan kepada the latest amendment, okay, dan juga berdasarkan kepada, saya rasa amendment ni sangat penting terutamanya sekarang bila kita berada dalam keadaan COVID dia menambahkan requirement for the arbitration in writing tu, okay, meaning that it will meet the requirement of the any electronic communication that the parties make by means of data message, if the information contained therein is accessible so as to the usable for subsequent reference. Maksudnya by email boleh, by WhatsApp boleh, by Telegram boleh, okay? Tidak semestinya secara bertulis itu di atas kertas sahaja, okay? Dan you need to know in terms of arbitration agreement, it must be in writing. Dia tak kata pun it must be signed by parties. Okay, it must be in writing. Dia tak kata pun it must be signed by parties. Meaning that the requirement hanyalah writing. Kalau parties tak sign, tak apa. Yeah, maksudnya it signify by way of writing. Okay, so subsection 5, subsection 5 to section 9 a reference in an agreement. Okay, a reference in an ada nak tanya soalan ke? Ahmad nak tanya soalan ke? Ada soalan nak ditanya ke Ahmad? Okey, boleh dengar Yang lain boleh dengar saya
Boleh dengar Doktor.
Boleh doktor.
Okey. Kalau dia online ni takut saya short sendiri cakap seorang you all tak dengar. Okey. Subsection 5, kalau you ada depan mata you sekarang ni, section 9 subsection 5, dia menyatakan bahawa a reference in an agreement to a document containing an arbitration clause shall constitute an arbitration agreement, provided that the agreement is in writing and the reference is such as to make that clause part of the agreement. So, ini yang dikatakan juga sebagai incorporation in writing. Incorporated by reference. Okay. Maksudnya dekat sini, dia adalah merupakan salah satu daripada agreement itself. Okay. So, you jangan bayangkan arbitration agreement ni macam agreement yang 4, 5, 10, 17 sampai 100 muka surat ya. Dia hanyalah kata orang macam serangkap pantun tu saja. Maknanya even though it is only one particular clause, a very short clause, and walaupun very short clause, dia adalah agreement by itself. Okay, dia adalah agreement by itself. Okay, so subsection 6 mengatakan bahawa for the purpose of this particular section, data message mean information generated, sent, received and stored by electronic, magnetic, optical or similar means, including but not limited to electronic data interchange, electronic mail, telegram, telex or telecopy. Okay. Right. Cuba kita tengok section 10. Section 10 adalah arbitration agreement and substantive claim before court. A court before which proceeding are brought in respect of a matter which is the subject of an arbitration agreement shall, where the party makes an application before taking any other steps in the proceeding, stay those proceeding and refer the parties to arbitration unless it's find that the agreement is null and void, inoperative or incapable of being performed. Ini you kena ingat baik-baik. You kena ingat betul-betul. Arbitration agreement is very important. Kalau arbitration agreement tersebut, okay, sebab apa? Pihak-pihak akan pergi kepada court dan berdasarkan kepada section 10, if let's say you file the matter to arbitration and the other party file the matter to the court, kalau misal kata dia tahu ada case arbitration, the court will stay its proceeding, bukan will stay the arbitration proceeding. It will stay their proceeding. Okay, pending the final disposal of the arbitration award. Kecuali kalau misal kata arbitration agreement tersebut inoperative, null and void or incapable of being performed. So that's why it is very important for you guys to know about the particular arbitration agreement. Okay, so that is actually interesting to note for you guys. So coming back into our lecture, our points here. E, there must be an intention to arbitrate, meaning that exclusively for arbitration. It must be clear, meaning that the dispute submitted to arbitration must be expressly clear as to what particular dispute. Is it relating to the non-payment issues? Is it relating to any certification? Okay, because you need to understand katalah in construction contract, isu utama dalam kata orang the dispute yang ada ni dalam dunia contract, construction contract adalah non-payment. Rasanya bukan construction contract sahaja isu berkaitan non-payment. Bila isu berkaitan non-payment issues ini, maknanya kegagalan untuk membayar, pembayaran hanya akan dibuat berdasarkan kepada certification by the professional. Okay, meaning that certification by the architect. Sebab dalam construction, payment will be made in stages. Okay, saja nak cerita kat you all kalau misalnya kata you attach dekat mana-mana firm and you dapat akses kepada contract you akan lihat bahawa payment in terms of construction will be made based on the progress and macam mana payment itu akan dibuat dengan adanya progress report. progress report itu will be certified by a professional, for example, by the architect. Okay, failure for the architect to certify, or if there is no certification towards that particular progress report, meaning that there will be no payment that can be authorized. Okay, so if let's say that the issues adalah berkaitan dengan non-payment issues, meaning that it will be part of the jurisdiction of the arbitration. Okay, dispute submitted to arbitration must be expressly and clearly. It means that apakah perkara yang you rasa you nak berikan kuasa, bidang kuasa kepada arbitration tu untuk buat keputusan. Okay, that is in a simple and a simple manner. Okay, then we look into the institutional or ad hoc arbitration. Institutional or ad hoc arbitration, for this particular situation, you need to refer to section 21. Section 21. Okay, section 21 is actually, what does it mean by the institutional or ad hoc? It means about the determination of rule and procedures. Okay, determination of the rule and procedures. Itu sebenarnya yang dimaksudkan. Dalam agreement tersebut, is it provided for any institutional rules? Provide for any institutional rule. Okay, so ini adalah benda penting yang ada dalam section 21. So kalau tak nanti apa pula doktor ni cerita pasal section 21 kan? So section 21 ni adalah lebih kepada apakah yang dimaksudkan dengan whether there is any particular rules by the institutional or it is ad hoc arbitration, meaning that what rules that will be applicable. Okay, dan juga apa yang ada dalam agreement tersebut perlulah ada berkaitan dengan arbitrators, appointment, numbers and qualification. This is based on section 13 Section 13 Alright. Berkaitan arbitrators ni you boleh lihat di bawah section 13 Apa kata kalau Arbitration Act tak menyebut apa-apa berkaitan dengan pelantikan arbitrator, you boleh tengok section 13 Maksudnya mana nak rujuk kalau misal kata arbitration agreement tak menyebut So default provision adalah section 13. Dan you boleh tengok section 13 subsection 3 13 subsection 3 and subsection 4 Okay, section 13 ini adalah section berkaitan dengan appointment of arbitrators. Okay, kalau you tengok appointment of arbitrators subsection 1, unless otherwise agreed by the parties, no person shall be precluded by reason of nationality from acting as an arbitrator. Subsection 1 dia mengatakan bahawa it doesn't matter lah apa juga kerakyatan seseorang tersebut. Dia tidak boleh disekat daripada menjadi arbitrator hanya kerana dia bukan seorang Malaysia. Only because he is not Malaysian, he cannot be appointed as arbitrator. Itu maksud subsection 1. Subsection 2, the parties are free to agree on the procedure for appointing the arbitrator or the presiding arbitrator. That is subsection 2. Parties pada mulanya mesti agree. Okay, ada contract between A and B. A dengan B mesti agree to the name of arbitrator yang nak dilantik. Kalau parties tak setuju, then pergi kepada subsection 3. Okay, kalau parties tak bersetuju, where the parties fail to agree on the procedure referred to under subsection 2 and the arbitration consists of 3 arbitrators, each party shall appoint 1 arbitrator and the 2 appointed arbitrators shall appoint the 3rd arbitrator as a presiding arbitrator. So kalau misal kata pihak-pihak tu tak bersetuju, okay, pihak-pihak tu tak bersetuju dan katalah dalam misal kata agreement tu menyatakan there should be 3 arbitrators. So macam mana nak lantik? Okey lah kalau tak setuju, A lantik awak punya, B lantik your own choice. Okey, dah ada 2 dah. Dah ada 2 arbitrator. Nak lantik arbitrator yang ketiga, okey, nak lantik arbitrator yang ketiga, the 2 arbitrators appointed by parties will appoint the 3rd arbitrator as the presiding arbitrators. Okay, as a presiding arbitrator. Okay, itu maksud dia di bawah subsection 3. Okay, tapi kalau misal kata ketegak juga maksudnya they fail to appoint any arbitrator within 30 days of the receipt. Okay, so apa yang mereka boleh buat? Okay, maksudnya dia boleh request dia boleh request pelantikan arbitrator tu kepada Director of Asian International Arbitration Centre Malaysia for such appointment. That is under subsection 4. Okay, subsection 4. Okay, So sama juga dalam keadaan kalau misal kata arbitrator tu hanya seorang, under subsection 5 pun sama, maka kena lantik, kena refer the matter to Director of Asian International Arbitration Centre. Okay, baik. The Director of the Asian International Arbitration Centre di bawah subsection 7 akan membuat pelantikan within 30 days from the request. Okay, dan kalau AIAC tidak boleh buat pelantikan, maka the parties may apply to the High Court for such appointment. Okay, for such appointment. Okay, and for the appointment, sometimes dalam arbitration agreement disebut what kind of arbitrators that must be appointed. In terms of qualification, in terms of any consideration, okay. So in terms of nationality, okay. So in terms maksudnya itu adalah requirement yang ada di dalam subsection 8, okay, di dalam subsection 8. Dan kalau pihak-pihak tak berpuas hati juga dengan pelantikan yang dibuat oleh pihak pengarah AIAC ataupun Hakim Mahkamah Tinggi, they cannot appeal the decision. They cannot appeal the decision under subsection 9. Okay, under subsection 9. So that is the important part that you need to know regarding pelantikan arbitrator berdasarkan kepada arbitration agreement. Dan saya nak sentuh sedikit, is there any other prerequisite requirement? Okay, the important part adalah that particular arbitrator must not raise any justifiable doubt towards independence and impartiality. Okay, so ini adalah benda penting yang berkaitan. What else? Okay, ada satu perkara yang you all kena faham juga berkaitan dengan arbitration agreement, selalunya akan menyatakan berkaitan the seat of arbitration. The seat of arbitration. Apa yang dimaksudkan dengan the seat of arbitration? It means the judicial home of the arbitration award and the procedural law that govern the arbitration, which include challenges to the award. And it is a merely geographical. It is merely, meaning that it is not based on the venue. Okay, seat of arbitration maksudnya dekat tempat mana yang you rasakan you nak iktiraf dia punya judicial home. Kalau arbitration tu dibuat di Malaysia, bermakna the rules of court berkaitan dengan arbitration akan terpakai. Itu nombor satu. Nombor dua, the procedural law that govern the arbitration will be the procedural law of the Arbitration Rules of Malaysia and also Arbitration Act of Malaysia 2005. Okay, so parties must follow the mandatory rules of the seat, and the seat will be determined based on apa yang benda yang paling penting sekali adalah the enforcement court mana yang boleh enforce, the validity of the agreement, okay, and it will regulate interim measures application. Okay, sebab you kena faham arbitration is international proceeding in nature. Okay, sebab dia govern under model law tu adalah di bawah New York Convention. Tetapi court adalah govern under the local and based on the territorial jurisdiction. You belajar MLS, you belajar berkaitan dengan jurisdiction of the court. Court adalah berdasarkan kepada territorial jurisdiction. So when it comes to territorial jurisdiction, of course lah, if let's say that particular arbitration matter, kalau dia adopt law of the seat in the Philippines atau Singapore, maksudnya court Malaysia tak ada bidang kuasa. Okay, court dekat Malaysia tak ada bidang kuasa. Okay, so kalau misal kata pihak-pihak tersebut nak minta interim measures, contoh injunction. Okay, contoh injunction. Okay, so mana dia nak pergi to assist the arbitration punya enforcement. Okay, contoh in terms of injunction untuk freeze an account. Sebab apa you nak freeze the account? Kalau you tak minta injunction to freeze the account, the party will transfer the account to any other account. At the end of the day, kalau misal kata you menang arbitration tersebut, there is no money to be paid to you. Sebab dia kata, oh, I don't have the money. So in order for you to seek for that particular injunction, you need to go to the High Court. Hanya High Court yang ada powers to issue injunction. Okay. And nowadays injunction maksudnya injunction tersebut is very important to assist the arbitration at the end of the day. Okay. And the seat of the arbitration will determine the award, recognition and enforcement. You must remember at the end of the day, apakah end product of arbitration? Ia adalah arbitration award. Bila you dapat arbitration award, apa yang you perlu buat? You must make sure that that particular award is being recognized in your country, okay? And for you to enforce that particular award. So in this particular situation, okay, the recognition and the enforcement is very important. So sebab itu court mana dia akan pergi kepada High Court for the recognition and enforcement. So kalau law of the seat tu adalah di Malaysia, you can go to Malaysian court for the enforcement and recognition. And also the important part adalah when you give that particular court a jurisdiction, the court also have the jurisdiction to challenge, okay, the award, okay, to determine the challenge of the award. Okay, so parties will choose seat based on the state. Negeri mana yang agak-agak pro arbitration. Okay, negeri mana yang agak-agak pro arbitration. Itu yang dinyatakan di bawah section 22. Cuba you tengok section 22 of the Arbitration Act. Section 22 of the Arbitration Act. Apa yang dinyatakan di bawah section 22 Arbitration Act, ya? It mention about what? The seat of arbitration. Section 22, subsection 1, the parties are free to agree on the seat of arbitration. Where the parties fail to agree, the seat of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. Including the convenience of the parties. Okay, and the arbitral tribunal, notwithstanding subsection 1 and subsection 2, and otherwise agreed by parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, expert or the parties, or for inspection of goods, other property or document. Okay, so law of the seat adalah berkaitan dengan judicial home. It will determine local jurisdiction of the court for enforcement, validity and challenges of the arbitration award. It will determine parties will determine which law of the seat, yeah, and it is very important, because why kenapa pihak-pihak memilih Malaysia sebagai contoh, because Malaysia under section 8 mention about no court shall intervene in arbitration matters except provided by the act. Sebab itulah kita buat pindaan in 2011, okay, untuk memasukkan berkaitan dengan no judicial intervention except in the matter which is provided under the act. Okay, and the seat is a legal seat. It is not just geographical location. Okay, so maksudnya, apa maksud law of the seat? The gravity, the center of that particular seat. So maksudnya kalau seat tu dekat Malaysia, dia tak boleh berubah ke daripada tempat lain, satu tempat ke satu tempat? Okay, Mahkamah Persekutuan memutuskan bahawa the actual venue may be shifted from home, judicial home from time to time without affecting the seat of arbitration. Which means if let's say that kalau you kata bahawa the law of the seat will be the law of Malaysia, for example, you can still have the arbitration proceeding to be held in Singapore, in Philippines, in Indonesia or wherever that you want to go. It will not affect the seat of arbitration. Okay, boleh? So what happen if arbitration acts silent on the law of the seat? The parties, meaning that if arbitration agreement is silent on the law of the seat, so it will be determined by the arbitral tribunal, and the arbitral tribunal will consider based on the circumstances of the case and the convenience of the parties under section 22, subsection 2. You must remember, arbitration agreement is actually if the law of the seat, the law of the seat determine the procedural law that need to be adopted it is not the same with the substantive law governing the substantive dispute. Inilah maksud the interplace of law in arbitration. Law of the seat adalah lebih kepada procedural law that need to be adopted, macam mana cara mengendalikan arbitration. Okay, dia bukanlah merupakan substantive law governing the substantive dispute. Contoh, Arbitration Act tak sama dengan Contract Act. Arbitration Act macam mana cara untuk kendalikan arbitration. Contract Act adalah macam mana untuk menyelesaikan pertikaian berdasarkan kepada kontrak tersebut. Sebab itulah ya, you kena ingat dia ada legal maxim. Satu adalah locus arbitri. Okay, locus arbitri. Locus arbitri. Satu lagi adalah lex arbitri. Okay. Locus arbitri bermaksud apakah law of the seat that determine the procedural law. Lex arbitri, in other words, adalah lebih kepada apakah substantive law that govern that particular dispute. So which mean locus arbitri ni Arbitration Act ataupun arbitration rule, lex arbitri adalah law of the contract. Okay. Section 37 instances where Arbitration Act will be ground for an application to set aside arbitration award. Okay. Kalau misal kata you nak bagi nasihat kepada you punya master ataupun you punya boss, you are lawyers, you kena make sure bahawa Arbitration Act, arbitration agreement mesti dibuat dengan teliti untuk mengelakkan daripada dia menjadi salah satu ground for an application to set aside the award. You dah menang 1 juta bos you menang 1 juta, secara tiba-tiba pihak tu kata, dia pergi kepada court, dia kata bahawa we would like the court to review into the arbitration agreement. Sebab apa arbitration agreement? Adanya clause-clause tertentu which is defective and inoperative. Okay. Contohnya, if arbitration agreement not valid under the law agreed by the parties or fail to indicate laws of Malaysia as law of the seat. Okay. So ini benda yang paling penting sekali. Sebab itu you kena lihat berkaitan dengan perkara ini. Alright. Okay. Next kita akan lihat seat theory. Ini adalah berdasarkan kepada model yang saya katakan tadi, model law. Okay. Dan kita bincang satu case ini berkaitan dengan bila kita kata law applicable to the substantive issue. Okay, law that applicable to the substantive issue. Adakah dia locus arbitri ataupun lex arbitri? Bila kita kata law applicable to the substantive issue, adakah dia locus arbitri ataupun lex arbitri?
Lex arbitri.
Lex arbitri. Lex.
Yes, lex arbitri. Okay. Maksudnya dia adalah berdasarkan kepada substantive issues. Choice of law terpulang kepada pihak-pihak untuk memilih. Dia nak pilih national law ke, dia nak pilih public international law atau any concurrent laws. Okay. So we have one case here. Government of Malaysia versus Government of India. Petrocon versus Government of India, di mana please bear with me benda ni mungkin kita dah bincang last week tapi just untuk kita bincang semula berkaitan dengan the parties were the respondents who were the Government of India as the and the contractor. Ni adalah berdasarkan kepada this particular production sharing contract which was executed between them, and the dispute arose between them with regards to the correctness of certain costs, recoveries and profit. The parties could not resolve their dispute amicably and referred the matter to arbitration under that particular clause of their contract, clause 34.3. The arbitral tribunal fixed the date of the hearing at Kuala Lumpur, Malaysia, but due to the outbreak of SARS, shifted the venue of its sitting to Amsterdam. And after that, they shift the arbitration proceeding to London. So dari Kuala Lumpur, they shifted sitting to Amsterdam in the first instance, and thereafter they shifted again to London. Thereafter, various proceedings were held by the Arbitral Tribunal at London and also partial award was subsequently passed. Maksudnya ada beberapa keputusan-keputusan, sebahagian daripada keputusan berkaitan dengan dispute pertaining to that production sharing contract telah pun diberikan oleh Arbitral Tribunal. So respondent tak berpuas hati, dia challenge the award tu, dia challenge the partial award tu dengan memfailkan petition di Mahkamah Tinggi Kuala Lumpur. Dan pihak perayu bila dia dapat tahu responden tu file di Mahkamah Tinggi Kuala Lumpur, dia mengatakan dia mempertikaikan tindakan responden by contending that by way of clause 34 in that particular agreement, only the English court has the jurisdiction to entertain any challenge of the award. Okay. So the respondent then make a request to the tribunal to conduct the remaining arbitral proceeding in Kuala Lumpur, but the request was rejected. Okay, and it was declared that the remaining arbitral proceeding would be held in London. At that stage, the respondent filed an application under Section 9 of the Arbitration Act of India, High Court, to stay the arbitral proceeding. Sebab you kena ingat satu pihak tu adalah Government of India, satu pihak tu adalah Petrocon, dan pada asalnya kontrak tersebut law of the seat adalah law of the seat Malaysia. The appellant objected dan dia mengatakan bahawa Court of India tak ada jurisdiction to entertain challenge of arbitral award. And High Court of India dia overrule appellant objection dan mengatakan bahawa High Court of India ada jurisdiction to entertain the petition filed under Section 9 of India Arbitration Act. So appellant ni merayu. Dan isu yang sekarang ni berada di Mahkamah Persekutuan adalah whether the Delhi Court could entertain the petition filed by the respondent under Section 9, okay, for grant of a declaration that Kuala Lumpur, which was the contractual and judicial seat for arbitration, okay, maksudnya dia nak buat satu deklarasi di India untuk mengatakan bahawa Kuala Lumpur ni adalah contractual dan juga judicial seat for arbitration, and for the issues of the direction of the to the Kuala Lumpur Tribunal to continue the hearing at Kuala Lumpur berdasarkan kepada clause 34 of that PAC. Okay, so apakah isu dia? Sama ada Kuala Lumpur was the judicial seat of arbitration and the same had been shifted to London where there had been oral consent of such a shift. Okay. Jadi kalau dapat lihat di sini bahawa adanya oral consent untuk memindahkan arbitration proceeding tersebut dari Kuala Lumpur ke Amsterdam dan kemudian ke London. Okay. The second issue would be whether the Delhi High Court had the jurisdiction to entertain the petition filed under Section 9 of the Act in spite of the choice of the parties for the agreement to be governed by the laws of England. So you kena ingat dalam agreement ini menyatakan bahawa the law of the seat will be in Kuala Lumpur. However, the laws that are applicable adalah the laws of London. Okay, so dia nak mengatakan bahawa that's why we go to the London in the first place, because sepatutnya undang-undang yang terpakai adalah undang-undang di London. Okay, so jawapan dia adalah apabila mahkamah membenarkan rayuan tersebut. Okay, mahkamah mengatakan bahawa the seat of arbitration berdasarkan kepada agreement adalah Kuala Lumpur. Okay, adalah di Kuala Lumpur. However, due to the outbreak of SARS, the party decided to hold their sitting first in Amsterdam and then in London, and the parties did not object to this. In the proceeding in London, the arbitral tribunal recorded the consent of the parties for the shifting of the judicial seat arbitration to London. Hence, whether this amounted to the physical or judicial seat of arbitration depended on a holistic interpretation of the relevant clause of PAC, which is the arbitration clause. According to the terms of the agreement, the seat of the arbitration was Kuala Lumpur. And if the parties wanted to amend clause 34(12), they could have done so by written instrument which was required to be signed by all of them. However, there was no such written instrument. Hence, the mere fact that the parties agreed to the shifting of the arbitral seat to London could not be interpreted as anything more than a physical change of the venue. Okay, maksudnya it is just a physical change of the venue from Kuala Lumpur to London. Okay, So in relation to the application under the Arbitration Act, India Arbitration Act, okay, the court actually referred to this particular Indian case, where it was held that the case under Part 1 would apply to all arbitration and all proceeding related thereto, where such arbitration was held in India, and the parties are free to deviate only to the extent permitted by the derogable provision of Part 1. In cases of international commercial arbitration held out of India, provision Part 1 would apply unless the parties by express or implied agreement excluded any or all of its provision. In such a case, the law or rules chosen by the parties would prevail. Any provision in Part 1 which is contrary or to or excluded by that law or rules would not apply. So in this case, the parties had agreed that notwithstanding of that particular clause, the arbitration agreement was to be governed by the law of England. This had the necessary implication that the parties had agreed to exclude the provision of Part 1 of the Indian Arbitration Act. As such, the Delhi High Court did not have the jurisdiction to entertain the petition filed by the respondent under that particular section, and the impugned order of the High Court was set aside. Which High Court? High Court in India was set aside, and the petition filed by the respondent is hereby dismissed. So what will be the main issue? Okay, I hope that you understand. Yeah. So the federal court in this particular case, yeah, you boleh tengok citation di situ, ya. In the absence of a seat, matter in arbitration agreement, federal court have to decide whether the seat, whether perkataan seat tu sama dengan maksud venue, tempat. Okay, so federal court mengatakan bahawa venue adalah sama dengan seat. However, venue is not geographical place ataupun seat as the later can be changed. Maksudnya, you can have your arbitration proceeding anywhere in the world. It will not change the law of the seat. Okay, so federal court mengatakan bahawa venue and seat are interchangeable in international arbitration. Once agreed, seat is permanent unless parties wish to change it. And in this case, federal court satisfied that the seat has changed from Kuala Lumpur to London. However, dia mengatakan bahawa it is only the change in terms of the geographical location. Okay. So, law of the seat, section 41 and 42, question of law arising out of the arbitration or award may be referred to High Court for determination. Ini you boleh tengok section 41 ya. Dia mengatakan berkaitan apa ya? 41 dan juga 42 ya. Dia berkaitan section 41 adalah determination of preliminary point of law by the court. Any party can go to the High Court, can go to High Court to determine any question of law. Regarding of what? Regarding of salah satunya adalah question of law except where that particular agreement state otherwise. Ini you boleh tengok di bawah subsection 3 of section 41 ya. Dan tengok juga berkaitan dengan section 40 section 42 section 42 telah pun dimansuhkan ya, telah pun dimansuhkan. Okay, so section 41 you can see apply to domestic arbitration and international arbitration if adopted ya. Dan ini adalah perkara-perkara yang kita kena lihat. So applicable law, what is applicable law? As I mentioned to you, there are interplays of law in arbitration, the law governing the arbitration agreement and the performance of that particular agreement. This is what that I mentioned to you, the differentiate between the lex arbitri and locus arbitri, which is the law or the relevant legal rules governing the substantive issues in dispute, generally described as the applicable law and the governing law, the proper law of the contract, for example, or the substantive law, for example, Sales of Goods Act. other applicable rules and non-binding guidelines and recommendation, and the law governing recognition and enforcement of the award, which may in practice prove to be not one law but two or more. So if recognition and enforcement is sought in more than one country in which the losing party has or is thought to have, in terms of that particular asset. Kadang-kadang they have arbitration in Malaysia but the assets are not in Malaysia. So it is very important in terms of recognition and enforcement, and there will be interplace of law between locus arbitri and lex arbitri in this particular situation. Language of arbitration, I believe that you know that it is pertaining to which particular language yang you nak pakai. I give you some example last week, in which let's say that the person, both parties, if they are from China, they prefer to use the language using Chinese language. So it is something which is straightforward in whatever language that they want. So this is also important consideration to be stated in the arbitration agreement. Kalau tak ada, meaning that the arbitral tribunal will decide based on the convenience of the parties. Okay, whether parties well versed in English or in Malay. Okay, next we go to the pathological clause. What is pathological clause? Pathological clause means that to describe an arbitration clause that is defective and which consequently raises question as to whether it can be enforced. Okay, so this is very important because they are going to look into the pathological clause. Okay, to see, as I mentioned to you, it is very important because to see, it is a yardstick. It is a yardstick in which to determine whether the court can intervene or not. Okay, as I mentioned to you. So they are going to look into this particular clause of arbitration agreement. Okay, so whether there is any defect, okay, that exhibit features of inconsistencies, uncertainty, or inoperability. And I give you some example there. For example, in terms of lack of clarity as to whether parties had intended to refer their dispute to arbitration or to the exclusion of the courts. Sometimes it is not clear. Okay, because sometimes, for example, there is a case in which the arbitration clause specifically say that if they have any matter or any dispute, they will refer to the arbitration and to the court. The arbitration and to the court. So it is not clear, lack of clarity. You want to refer the matter to arbitration or to the court because you mentioned both in that particular arbitration agreement. Secondly, the defect can be exhibit in terms of reference to an appointing authority which does not exist. Okay, for example, we have a case in which the arbitration agreement mentioned about if you have any dispute, then you can refer the matter to international chambers of commerce of arbitration of Malaysia. Okay, dia sebut berkaitan dengan International Chambers of Commerce of Arbitration in Kuala Lumpur or Malaysia, which it does not exist. Kalau you sebut berkaitan dengan any appointing authority which does not exist, it means that there is a defect and your arbitration agreement automatically inoperative and open to the intervention of the court. Nombor 3 adalah ambiguity. Okay, ambiguity in terms of reference to a country instead of a city as the seat of arbitration in the situation which give rise to ambiguity as to the actual seat intended. You nak buat dekat mana sebenarnya? Contohnya law of the seat adalah law of Johor Bahru, for example. Okay, law of the seat adalah law of Kelantan, for example. So the reference of country instead of the reference of city instead of country adalah sesuatu yang inoperative. Sebab Johor dengan Kelantan, they do not have any arbitration act. Okay, arbitration act adalah kalau misalnya kata you refer to Malaysia, for example, or Kuala Lumpur. Okay, so that is number 3. Number 4, dia ada kena mengenai juga dengan number 3 provision that the arbitration is to be administered by an arbitration institution which does not exist. Okay, meaning that yang nombor 2 tadi adalah badan mana yang nak melantik arbitration. You sebutkan nama badan tersebut dengan salah, wrong reference to that particular arbitration institution. Same goes to the number 4 provision. Arbitration tu you nak administer with whom? Okay, with which body? Okay, So that is the important. Number 5, if the arbitration agreement spells out about if let's say there is any dispute, okay, so the law of the seat or the rules that will be applicable will be the rules of arbitration in Malaysia and the rules of arbitration in Indonesia, for example. So you are referring into one or more, you are referring into two or more, more than one rules of arbitration, okay, more than one rules of arbitration, okay. Refer to more than one arbitration rule. So this is very important, yeah. This is very important because it shows lack of clarity and also common defect. What else? What else? Mungkin ada mengatakan provision of the arbitration is to be administered by the arbitral institution using rules of another arbitral institution in the situation where the administration institution does not have organizational structure. Ini sebagai contoh, okay, if you have a dispute, you will refer the matter to AIAC, but the rules will be applicable will be the rules of ICC, International Chambers of Commerce, in which itu adalah satu yang defektif sebab kalau you refer to AIAC will have its own arbitration rules. Same goes to AIADR. Saya post dekat you dalam MS Teams tu. There will be AIADR. Okay, apa beza AIADR dengan AIAC? AIAC ditubuhkan berdasarkan kepada International Convention, okay, ALCO, Asian African Consultative Legal Consultative Organization, okay, yang berpangkalan di India. So AIAC adalah international body, okay, established by the international body established under the international instrument in which Malaysia adalah parties to that particular instrument, okay, dan it is not any organisation under the government of Malaysia, so it is independent. Itu AIAC. AIADR adalah Asian Institute of Alternative Dispute Resolution, in which it is established under the Companies Act. It is a company by itself. It is an institute providing the arbitration services. Dia sama dengan AIAC, tetapi AIADR ni dia bukan international body. Dia adalah lebih kepada company incorporated in Malaysia, tetapi dia buat international, dia offer international arbitration services. Okay, sebab itulah kalau kita dapat lihat itu beza dia. So namun kalau misal kata as I announce dalam dalam group, if let's say that you are interested untuk buat you punya internship dekat AIADR, then let me know, okay, so that I can give you maksudnya how to apply, how to apply the internship kat situ. Coming back into the pathological clause, apakah lagi perbezaan, apakah lagi contoh-contoh a defect arbitration agreement. Contoh kalau provision for arbitration in an unidentified third country under the rules of that unidentified third country. Maksudnya you nak kata benda tu refer kepada AIAC, tetapi kemudian you kata bahawa law of the seat tu adalah terpulang kepada negara ketiga, in which you tak nyatakan berkaitan negara mana. Okay, ataupun if let's say that the procedures adalah appointment of the 3 arbitrators with each parties appointing an arbitrator, you tak sebut berkaitan dengan how to appoint the third arbitrator. Okay, how to appoint the third arbitrator, for example. Okay, and inconsistency with other clauses in the contract, such as one clause providing for dispute to be referred to arbitration, while another clause provide for the same dispute to be referred to the court. Okay, so this is case yang ada lah yang berkaitan dengan, if let's say you want to refer the dispute to arbitration, dia tak sama dengan multi-tiered. Multi-tiered arbitration ni maksudnya you are going to resolve your matter based on that particular tier. First go for negotiation. Gagal baru pergi kepada mediation. Gagal baru pergi kepada arbitration. Tapi kalau misal kata dalam agreement tu mengatakan bahawa clause 13 mengatakan bahawa contoh you can refer the matter to arbitration, tiba-tiba you baca clause 21 atau clause 36 kat belakang tu mengatakan bahawa if you have any dispute you can refer the matter to the court. So you nak refer mana satu? Okay, sebab ada di ada dua dispute resolution clauses. Okay. Alright. Okay. Okay, a clause in an agreement which provide the court shall have exclusive jurisdiction would not render the arbitration clause in the agreement inoperable, because sometimes dia ada menyatakan bahawa satu clause tu kalau you refer the matter to arbitration, dia akan ada clause kat belakang mengatakan bahawa walau bagaimanapun, walau apa jua, maknanya in any event, okay, in this particular contract, it will not oust the jurisdiction of the court. Dalam satu maksudnya dalam satu clause yang lain. Okay, itu bermakna walaupun adanya clause mengatakan bahawa law of Malaysia will be applicable and High Court of Malaysia will have exclusive jurisdiction, dia bukan bermakna arbitration clause tadi adalah inoperable. Okay, dia tidak bermakna kalau ada clause berkaitan dengan exclusive jurisdiction of the High Court, it does not mean that the arbitration agreement sebagai inoperable. Okay, because such clauses have been construed to mean that the court have supervisory jurisdiction over the arbitration. Okay, maksudnya court ada supervisory jurisdiction over the arbitration. Okay, where a contract contain provision for dispute to be referred to arbitration but also provide for dispute to be referred to the court may still be persuaded to give effect to the provision on the arbitration. Okay, maksudnya court kena mengambil kira dan juga memberi ruang kepada arbitration. Okay, there are some cases in which nanti kita akan bincangkan dalam tutorial yang akan datang, ya, in which it will be a task based for the tutorial group, ya, untuk membincangkan yang berkaitan dengan isu ini, ya. Sebagai contoh bahawa ada kes-kes, ya, yang akan dibincangkan tentang isu ini. Alright. Okay, ini pathological clause. Okay, lack of clarity. What happen if there is a lack of clarity? You need to refer. Okay, reference as to appointing authority, more than one rules of arbitration, ambiguity, reference to the country, arbitration to be administered, which institution, numbers and qualification of arbitrators, and inconsistency with other provision. Ini adalah features dalam pathological clause. Next adalah multi-tiered, ya. Multi-tiered. Apa maksud multi-tiered, ya? Multi-tiered dispute clause adalah agreeing to arbitrate dispute does not mean parties cannot first try to resolve their dispute by other non-adversarial means, and it is open to the parties to provide in their agreement that if a dispute arises, they should first try to resolve it amicably by negotiation, and if that fail, through mediation. And arbitration is thus reserved as a remedy of last resort. Okay, so this multi-tiered dispute clause would provide parties with a pathway to resolve their dispute in non-adversarial manner. Okay, in a non-adversarial manner. Apa maksud non-adversarial manner? Apa maksud non-adversarial manner? Siapa tahu? Apa maksud non-adversarial manner? Non-adversarial manner bermaksud without any adversarial systems of the court. Okay, judicial adversarial system. Adversarial system ni maksud dia adalah dia ada satu adversarial system, satu lagi inquisitorial system. Adversarial system, apa yang you all belajar sekarang ni? Prepare your case, prepare your bundle, prepare your argument, you go to the court to present your case. Judge buat apa? Duduk atas bench, dengar dan buat keputusan. In an inquisitorial system, you provide the court based on what that the court will ask you to do. Okay, so court akan jadi aktif active judges that will conduct the matter actively as a judicial investigator. Okay, so non-adversarial ni adalah sesuatu yang mana dia out of court punya sistem. Okay, contoh negotiation and mediation kita dah belajar kan, tidak ada unsur-unsur berkaitan dengan formality macam dekat court. Okay, so they are considered to be non-adversarial manner. Okay, hence the additional time and costs it would entail in complying with a multi-tiered dispute clause can often be well worth incurring to avoid the substantial time and expense and uncertainty inherent in any adversarial process and the inevitable adverse effect it has on the business relationship. As I mentioned to you before, multi-tier dispute clause maksudnya in negotiation ataupun in any other situation. Why the corporate try to evade? Because satu, dia tak nak lantik peguam bayar mahal katanya lah. Okay, it's relating to cost, it's relating to time. Okay, because time is of essence. You must remember, especially in construction, you need to deal with that particular matter as soon as possible. You cannot wait until the court untuk bersidang. Contoh sekarang ni, court bersidang. Court tak bersidang because of COVID. Okay, only certain application that can be made online. Okay, it will take time for the parties even go to any formal dispute resolution mechanism. Okay, so negotiation, mediation, arbitration considered to be fast and rapid. Yeah, fast and rapid. Arbitration, not to say that it is going to be a fast rapid as well. Sebab arbitration adalah lebih kurang macam private court. Okay, in terms of cost pun tidaklah bermakna cost tu lebih murah daripada cost mahkamah sebab cost arbitration adalah tinggi juga, relatively high, dan juga the process will be relatively longer than negotiation and mediation. Okay, but multi-tiered actually will give parties more option. So that's why to be effective, a multi-tiered dispute clause should be couched in terms that make the obligation to resolve the dispute using each tier of dispute resolution mechanism as mandatory before a party can engage in arbitration. So this is why what we call as escalation clause. Escalation clause. A multi-tiered dispute clause should therefore clearly set out the obligation imposed on the parties so that compliance with the pre-arbitration dispute provision is a condition precedent to the arbitration. Okay, so if let's say that they have two-tiered, for example, some of the agreement will have a grace period of time. Okay, we'll have a grace period of time in order to settle the matter. Okay, we are going to discuss this in tutorial as well in your case case review task. Okay, then about multi-party and multi-contract arbitration. Typically an arbitration is between two contracting parties in which commonly consented and it is part and also foundation of the arbitration, and agreement of the parties is therefore strictly required before a third party can be joined either as additional claimant, respondent or intervener. Okay, parties may therefore in their agreement provide for third parties to be joined and empower the arbitral tribunal to join third parties in any arbitration, and this is what we call as a third party intervention. Okay, where there are several parties to the contract containing the arbitration clause and the arbitration involves some but not all the parties, a party to the arbitration can apply to the arbitral tribunal to join a contracting party who is not in the arbitration. This can be seen, for example, in the construction cases in which they involve a main contractor, subcontractor, subcontractor along the way. Okay, so because of the, let's say, subcontractor subcontract agreement actually entered between main contractor and the subcontractor. So what happened to the subcontractor? They are the third party, and normally you learn about privity of contract. They cannot get involved. So what that they can do? Okay, can they be involved in that particular arbitration? Yes, they can if the parties make an application for them to be an intervener. Intervener, okay? Ataupun mencelah lah dalam bahasa Melayu ya, sebagai mencelah kepada proceeding tersebut. Okay? Ini satu contoh tapi contoh ni adalah bukan merupakan contoh dalam arbitration ya. If you still remember keputusan berkaitan dengan kes Altantuya ya, yang baru diputuskan oleh Mahkamah Persekutuan ya, in which that particular special branch officer has been accused, convicted bersama-sama dengan Razak Baginda, tapi Razak Baginda telah dibebaskan. Dan kemudian dia lari daripada Malaysia dan dia bersembunyi di Australia. So dia telah buat permohonan oleh sebab dia tak ada kat Malaysia kan. Jadi dia telah buat permohonan untuk mencabar keputusan. Sebenarnya apabila dia dihukum gantung, dia telah buat rayuan berkaitan hukuman gantung tersebut di Mahkamah Rayuan dan Mahkamah Tinggi. Sajalah nak cerita ni kan. Sebab nanti CPC you all pun akan belajar berkaitan dengan appeal. Okay. Rayuan. Dia telah buat rayuan. Dan rayuan dia telah ditolak oleh Mahkamah Persekutuan sebagai, kata orang, the ultimate and the final resort. Kalau you buat appeal, that is the final appeal yang you boleh buat. Okay. Tetapi dia cuba untuk dia memfailkan semula semakan kehakiman berkaitan dengan rayuan dia tu dengan memasukkan satu statutory declaration yang mengatakan bahawa beliau telah diarahkan oleh Datuk Seri Najib untuk menembak ataupun membunuh Altantuya. Dan pada ketika Mahkamah Persekutuan untuk membuat keputusan, Datuk Seri Najib telah pun memohon untuk mencelah. Permohonan untuk mencelah ya. Maksudnya dia cuba untuk masuk untuk mencelah dalam prosiding supaya dia akan jadi salah satu pihak dalam prosiding tersebut. Tetapi Mahkamah Persekutuan telah pun menolak permohonan Datuk Seri Najib dan pada masa yang sama telah menolak semakan kehakiman yang telah dibuat oleh that particular SB person ya. So meaning that hukuman gantung dia adalah kekal. Okay, dan tak silap saya dalam proses untuk membawa balik beliau ke Malaysia. Alright. Okay. Alright. In relation to the consideration for the arbitration agreement, you need to know as well there will be some consideration, for example the law of agreement, in which law that you need to apply. Is it the law of Malaysia? Confidentiality confidentiality also is very important tapi confidentiality ni kalau saya nak rujuk you all bahawa we have a new amendment dalam Arbitration Act berkaitan dengan confidentiality in which it is very important juga ya. Kejap saya tengah cari section berapa semalam jumpa tu. Anybody boleh highlight pada saya section berapa berkaitan dengan confidentiality dalam Arbitration Act? Section 41A. Section 41A Section 41A adalah merupakan section yang mana melarang sebarang disclosure of information relating to arbitral proceeding and award oleh pihak-pihak di bawah section 41A. Dan di bawah section 41B, this is also a new section. Normally arbitration ni memang confidential normally. Tapi kalau ada pihak-pihak mula bawa kes ke mahkamah civil, for example dia nak minta injunction, for example dia nak appeal, for example dia nak buat permohonan untuk quash the award, for example arbitration award. So bila dia pergi pada mahkamah civil, of course mahkamah civil ni dia akan jadi open court. Dan di situlah baru you tahu bahawa company ni rupanya ada arbitration case. Okay. So di bawah section 41B, kalau salah satu pihak dia membawa perkara itu kepada mahkamah sivil, keseluruhan prosiding tersebut tidak boleh dihebahkan. No disclosure ya. Kalau you tengok kepada section 41B ya. Section 41B, jumpa tak section 41B? Okay. Court proceeding under this act are to be heard otherwise than in an open court. Okay. Meaning that if any party make an application or if any party make any application regarding the proceeding, okay, regarding the proceeding of any application that relates to arbitration, okay, so it will be heard otherwise than in open court. Maksudnya dia still confidential in this particular situation. Dia tidak akan dibuat di dalam mahkamah terbuka, okay, di dalam mahkamah terbuka. Itu di bawah section 41B. Dan confidential adalah di bawah section 41A. Okay. Benda ni you nak kena betul-betul ingat ya, 41A and section 41B which relate to confidentiality. Okay. Boleh? Alright. Then you must also bear in mind regarding the interest. Okay, interest ini apa? Interest you boleh lihat kepada section 36. Sorry, section 33 subsection 6. Okay. And also cost. Apa beza interest dengan cost? Ni you kena tahulah ya, sebab nanti you buat civil litigation you akan buat drafting kan. Cost adalah cost proceeding, interest adalah interest berkaitan dengan pre and also post judgment award. Okay. Sama juga dalam arbitration, pre and also post arbitration award. Okay. So interest adalah interest berkaitan dengan jumlah yang you tuntut. Cost adalah cost berkaitan dengan cost proceeding. Okay. So dia ada cost of suing for example. Okay. Suing bukan menjahit cost untuk mendakwa Dalam civil litigation adanya terms berkaitan suing and defending. Okay. So cost of suing, cost of defending Dan juga lihat kepada limitation of time. Limitation of time, jangan lupa limitation of time adalah 6 tahun berkaitan dengan limitation of time. Cuba tengok section 45. Okay, section 45 Arbitration Act where an arbitration agreement provide that arbitral proceeding are to be commenced within the time specified in the agreement. The High Court may, notwithstanding that the specified time has expired, extend the time for such period and on such term as it thinks fit, if it is on the opinion of the circumstances of the case undue hardship would otherwise be caused. Okay. So berkaitan dengan limitation of time, maksudnya kalau dia berdasarkan kepada section 45. Section 45 ni maksudnya jika di dalam arbitration agreement menyatakan adanya tempoh masa tertentu untuk you refer the matter to arbitration, dan kalau tempoh itu lapse, kalau tempoh itu telah pun tamat, you can go to the High Court under section 45 and High Court will extend that particular time frame. Itu maksud dia. Okay, what will be the time frame punya tempoh? Dia akan sama mengikut kepada limitation of time provided by the that particular national law. Kalau kat Malaysia 6 tahun. Okay, under section 45 the High Court may take into consideration apa? Okay, maksudnya kalau misal kata dalam arbitration agreement tu menyatakan tempoh 3 tahun, but you bring that matter to arbitration after the third year. Okay, so meaning that you brought up the issues after the time has lapsed, so you can go to the High Court and the High Court may take into consideration. There are 6 consideration that the High Court will take into consideration. For example, first, the length of the delay, how long the delay has occurred. Second, the amount at stake, how much actually how much involved in terms of claim that need to be considered by the arbitration. Whether the delay was due to the fault of the claimant or to the circumstances outside his control. Okay, itu perkara yang ketiga. Perkara keempat, if it was due to the fault of the claimant and the degree of such fault. Okay. Number 5, whether the claimant was misled by the other party. And last kali, whether the other party has been prejudiced by the delay, and if so, the degree of such prejudice. Okay, so this is very important. However, ini nak kena faham juga, Section 45 does not apply to all arbitration. For international arbitration, that has to be an express agreement to adopt Section 45. Sebab Section 45 ni termasuk dalam Part 3 dan international arbitration tidak terpakai tidak terpakai international arbitration, okay, kecuali pihak-pihak menerima pakai, okay, kecuali pihak-pihak menerima pakai perkara tersebut. Alright. Satu lagi adalah relating to IBAR rules and guideline. IBAR rules ni adalah International Bar Association. International Bar Association ni dia ada keluarkan guideline berkaitan dengan rules in taking evidence in international arbitration. Because I mentioned to you, sila tengok Evidence Act 1950. Evidence Act 1950 Malaysia tidak terpakai untuk arbitration, especially international arbitration. Because why? Evidence Act adalah terpakai hanya untuk kes-kes di Malaysia sahaja. Tapi kalau arbitration tu adalah dia memilih locus arbitri Malaysia, adakah Arbitration Act akan terpakai? Jawapannya masih juga tidak. Sebab Arbitration Act dah jelas mengatakan bahawa tidak terpakai untuk kes-kes melibatkan arbitration. Dan berkaitan finality, whether arbitration agreement as final and binding, okay, you boleh tengok section 36. Section 36 ya. In which Section 36 of the Arbitration Act 2005 mengatakan bahawa an award is final and binding. An award made by arbitral tribunal pursuant to an arbitration agreement shall be final and binding on the parties and may be relied upon by any party by way of defense, set off, and otherwise in any proceeding in any court. And the arbitral tribunal shall not vary. The arbitral tribunal shall not vary, shall not amend, shall not correct, shall not review, shall not act to, and shall not revoke an award which has been made except specifically provided for under Section 35. And Section 35 adalah sesuatu yang berkaitan dengan correction and interpretation of an award. This is also very interesting. You pernah dengar perkataan functious officio? Have you guys heard about functious officio?
Pernah.
What is functious officio? Apa itu functious officio? Nanti kalau LPQB datang, dia akan tanya soalan-soalan yang basic tau. Apa itu functious officio? Apa itu audi alteram partem? Contoh lah kan. Dia takkan tanya you berkaitan dengan isu-isu dia takkan tanya berkaitan dengan section 117 pasal apa? Walaupun you nak kena tahu jugalah kan. Okay, functious officio adalah berkaitan apa?
Let's say the judgment has been given, the judgment cannot be reversed or cannot be changed.
Okay, boleh juga. Okay, thank you. Maksudnya once the court has make a decision, okay, once the matter has been decided, then the court cannot change or alter, okay, that particular judgment or award. Okay, same goes to the arbitration. Dia ada juga functious officio. Dalam tempoh 30 hari, pihak-pihak tersebut boleh untuk membuat permohonan supaya adanya correction. Correction can be made towards the award or will have an additional award. Okay, tetapi it will be limited towards apa? Towards any typographical or clerical error or any other error of similar nature. Okay, and there will be a notice in which the arbitral tribunal need to give an interpretation of a specific point or parts to make the award more clear, okay, to avoid any lack of clarity. So for the purpose of clarity and for the purpose of clerical and also typographical error. Okay, boleh? Alright, that is finality. That's it. That's it for today. Any question? Is there any question? Ada apa-apa soalan yang ingin ditanyakan? Ada soalan? Tak ada soalan? Okey. Tak ada soalan nampak gayanya. Alright, kalau tak ada soalan, our lecture will come to an end here. So if you have anything, you may ask me. Okay. Kalau tak ada, should be okay. So which means you all faham, and we are going to I'll going to assign you into a few cases that we need to look together. Okay. So to have a better understanding, in particular regarding to arbitration. Is there any other question? Kalau tak ada, okay. Kalau tak ada, then that's all for today. Thank you. Stay safe. Jaga diri baik-baik. Okay. Dan selamat bercuti pada hujung minggu ini yang agak panjang. Alright. Kalau balik kampung tu pun berhati-hatilah di jalan raya. Okay. Kalau main basikal, jangan main dekat atas jalan raya ya. Alright. Okay. So thank you. Assalamualaikum warahmatullahi wabarakatuh. Jumpa lagi.
Waalaikumsalam warahmatullahi wabarakatuh. Terima kasih doktor.
Sama.